The divorce or dissolution procedures to make a formal end to your relationship, whether that's a marriage or a civil partnership. A less common alternative is known as judicial separation, and that tends to be used by couples that, for religious reasons, don't want to divorce or formally dissolve their civil partnership. There's only one ground for divorce and dissolution, and that is that the relationship is irretrievably broken down. To satisfy the court of that, you'll have to rely on one of 5 facts, or in dissolution, only one of 4 facts are available to rely on. So those 5 facts are the unreasonable behaviour of the other party, 2 years separation with consent, which means the other party needs to give their consent to the proceedings going through, 2 years desertion, 5 years separation, which again is going to cause a longer delay if you're wanting to get the relationship formally ended sooner rather than later, and finally adultery, which you can only rely on in divorce proceedings and not in dissolution proceedings. We can advise on which of those facts is most relevant to you and best to rely on if you are wanting to petition. The timescale involved with divorce or dissolution, it can be anything from 6 months upwards, and it does depend on what the parties want to do with the proceedings and how long these things are going to take if they want to resolve financial matters and such like. The procedure for both petitions, whether it's divorce or dissolution, is broadly the same. So the first step is that the petitioner, who's the party that wants to initiate the proceedings, has to file a petition with the court, and that will set out the facts that they're relying on and details of the marriage, and there'll be various supporting documents required with that. That will then be issued by the court, who will send a copy to the other party, who is then known as the respondent. And the respondent will have to fill in a form called an acknowledgement of service, and that just sets out their position on the divorce or dissolution and makes clear what their views are. From that stage, once the court has received and processed that, the petitioner can file an application for the decree nisi, which is the first temporary decree of divorce, and in dissolution it's known as a conditional order. But they're broadly the same thing, and they're just the first stage of the divorce process. From that point onwards, there has to then be a delay of 6 weeks, so you can't apply until 6 weeks has passed. And at that stage, you can lodge your final application for the decree absolute or a final order in dissolution. And that's basically the final decree of divorce or dissolution. It formally ends the relationship, and that's the end of the marriage or the civil partnership. The reason some people don't make that application straight away is because they want to spend a little longer negotiating financial matters arising from their separation, and that's when the timescale can get slightly longer. But apart from that, the 6 months timescale is an average estimate for you.